I think today would be a good day to talk about the veterans' application for compensation and the appeal process, Tom, because a lot of veterans are denied their application for compensation, and subsequently they feel the appeal is the way to go to correct that situation.
In my view, from what I've seen over the years and my experience as a senior adjudicator with the VA and as a lawyer thereafter, I would say the very best thing a veteran can do is to prepare his case so that he or she can avoid an appeal. Spend a great deal of time preparing your claim, lining up all the ducks, building up all the evidence you need to make sure that you have a workable claim, and then submit it, rather than firing from the hip and for some benefit that you think you're entitled to, but you're just not really quite sure whether you meet the VA standards. In my view, we shouldn't let the VA decide whether you hit this mark that they've set for you. In consultation with a veteran service officer, I would say, a good one, build up all the medical evidence before you file a claim and see whether the evidence that you already have in terms of your treating doctor's reports, the doctors who may treat you for whatever condition it is at the VA, private doctors, and see whether or not when you examine all that evidence, it meets the threshold for whatever benefit that you're trying to obtain.
So it's so important to have that application done correctly when you come out of the gate to the VA for a compensation claim. Absolutely.
Right.
There are, of course, a lot of reasons for claims being denied. There are a multitude of reasons why a claim is denied. Insufficient evidence. You've already said if you can provide all the information the Veterans Administration needs, and all you got to do is think about it. If you're going to apply for a blown out knee, the Veterans Administration needs to know you injured that knee in the service, or if you had that knee condition before you entered the service, you aggravated it during your military service. There has to be a connection in your service and the injury today. Those are the basics. If there are no medical records available when you file the claim, somebody's got to get them, and it's the VA. And often the VA comes back and says no records available. And what do? You appeal. And had you done your homework to start with, you could have obtained the records yourself, cut down the process significantly, been awarded a compensation from the VA for that knee condition.
Assuming the veteran has already built up adequate evidence, but something goes wrong and the VA decides that his or her claim is denied, I think there's yet another option they have at this stage before they go to a full-fledged appeal, isn't there?
Absolutely, you're right. As a matter of fact, there are a couple of things that can be done prior to going to the full-fledged appeal. Right. One is asking for a reconsideration. You read the reason for the denial, and you can correct or amend that reason stated by the VA for denying benefits. And so you fix that, you correct it, and you send it back to the Veterans Administration requesting a reconsideration for service connection for the left shoulder. You have documented evidence supporting that, and in a lot of cases, given that information, the Veterans Administration can overturn the original denial. Case closed, you take the money and you're on. You have the service-connected disability. Yeah.
What did the VA, what I'm not clear on, Dave, is what did the VA do wrong that could be corrected so quickly in the example you gave?
Well,
for example, with the knee or the shoulder.
Let's say the veteran inadvertently put down the right shoulder when the left shoulder is the damaged shoulder. And the Veterans Administration, you can't assume they're going to be logical and say you must have made a mistake, it's your left shoulder that's damaged. The VA doesn't do that. They're going to come back and deny the claim because there's nothing wrong with your right shoulder. And you say, this is a reconsideration, it's my left shoulder that was damaged, please award compensation. And there you have it.
Gotcha.
It's overly simplified, but in a multitude of situations, which we can't cover all of them. But anyway, that's essentially the way it goes.
Right. And yet, there's still one more process that they can go through.
The DRO, the Decision Review Officer. A veteran has the option of asking to be heard in front of the Decision Review Officer at the Department of Veterans Affairs and pleading his case. And if he has retained the help of a service organization, that service organization can be with him at the Veterans Administration during the hearing to assist him in pleading his case.
So really, this is like a second bite of the apple, isn't it?
Yes, yes it is, yeah.
And if the veteran hadn't requested that DRO, Decision Review Officer, review at the regional office level, he would or she would have missed the opportunity then to get that second level of review at the regional office level.
Exactly.
Their case would have gone right to the Board of Veterans Appeals.
And he would have missed that step that could have overturned the original denial. You're absolutely correct.
Right. And it could have been done perhaps very timely.
Very timely, yes, in consideration to the Board of Veterans Appeals, or BVA.
Right.
I never thought I'd have a chance to question an attorney, but I want to ask you something. You stated earlier that you spent 10 years with the Veterans Administration as an adjudicator.
That's right.
I would like to know, I'd like you to share some of that experience you had with the VA as an adjudicator and see if there's any information that can be helpful.
Sure. Well, I think an insider's view would be helpful to the veterans so that you can understand that the VA, believe it or not, is understaffed and undertrained. And the adjudicators, all of those who participate in this claims decision are under the gun to get things done. And they have a system there that, even though it's been how many years since I was an adjudicator, is still in place, where they take, quote, in products for work that they do, in products. Otherwise, they don't get credit for work. So the tendency is to try to reach a quick decision so that you can take a, quote, in product, and you shine a little better because you have more of those in products than the guy or gal sitting over here doing the same type of work.
The end product is the completion of the case,
case. A decision.
A decision has been made on a case, that's the end product, so now that case is done, whether it's correct or not, but that case is done as far as the adjudicator is concerned, so he's looking for some kudos because he's completed another case.
Right.
Okay.
So you can imagine, under that kind of pressure, there's going to be a strong temptation to try to decide things more quickly than they should have been decided without due consideration for the veteran. And that, unfortunately, is what happens, and that, compounded with a lack of training and being undermanned, leads to just legions of errors on the part of the VA in deciding cases. So I hope that provides just a little bit of insight into what's going on within the VA.
Well, Tom, if I was the veteran that watches us, I'd say I'm going to really be careful about my application when I initially file an application. You know, the guy that says, my wife has been on me to go to the VA about my back. She knows I heard it in the service, and I never had time to file a claim. I would really be careful about the initial filing of the claim to maybe seek out a service officer. And we're not on service officers, but I want to get on service officers for a minute. They're like used car salesmen. They're like doctors. They're like lawyers. You got to kiss a lot of frogs before you get to a prince. And this is to say that you need to be comfortable and confident with the service officer you get. A lot of times when I'm working with guys, I'll say, you may not know anything about the transmission of your car, but as you watch that mechanic work, you can tell if he knows what he's doing. And you, having had the experience of being together with a lot of men for a long period of time, you have instincts. And those instincts will tell you if it's right, if it feels okay, or if it doesn't. So it would be a good idea to have someone help with that initial claim.
Right. You could also if you didn't trust your instincts quite as much, you might beat the bushes to try to get some referrals to a service officer who had already done a good job, say, for another veteran in another case.
Right.
Let's say, however, that it just doesn't work out. You've done all your homework, you've done everything correctly, and yet the VA still has decided that they're going to deny your claim. Well, there are some critical dates to remember. And the first date to remember is that you have 1 year from the date of the letter that the VA sent in denying your claim. 1 year from that date to file a notice of disagreement with the VA decision. That's really a kind of appeal. They call it a notice of disagreement. It's the first stage, really, in the appeal process. And this notice of disagreement has to be in writing, and it's got to express your desire to reverse the decision and take it up on appeal. You have to put that in writing. Now, let's say you've done that, and you've done it within 1 year. And by the way, you have to send that written notice of disagreement, which could be on anything, really. But I would suggest using VA Form 21-4138, a statement in support of claim, to do it. If you can't use that, use something else. But get it in within that 1 year period, and the sooner the better. Once that's done, the VA is required to send you something called a statement of the case. This summarizes the evidence in the case and the law, and explains their decision. There's a rating decision that will be attached. Regardless, once you get that statement of the case, you have 60 days to file a Form 19. The 19 is attached to the statement of the case. And you file that also at the regional office. You don't send it off to the Board of Veterans' Appeals. It too goes to the regional office, just like the notice of disagreement did. Bear this in mind, you have to send it to the same office that made the decision, unless the file, for whatever reason, has been transferred to another office. In that case, you'd send your notice of disagreement in your 19 form to the new office.
Tom, just a quick question. All the information you just provided, is that information sent to you from the Veterans Administration when you basically initiate the appeal?
It is, and I think it can't be emphasized enough. Even though they send that information, I've seen veterans blow timelines, statutes of limitations like that, wait longer than a year, and then their case, they haven't lost it forever, because that's the nice thing about the VA system. You can come back for yet another effort with more evidence. But what you're going to miss out on is the effective date. If you ultimately succeed, you're going to miss out on the earlier effective date that you had when you filed that claim earlier. And let me add one more bit of information, technical information that I think is useful. When you file that Form 19, I would add this language. Appellant hereby takes exception to and preserves for appeal all errors the VA regional office may have made or the board may hereafter make in deciding this appeal. This includes errors in failing to adjudicate issues or claims reasonably raised by the record, even though not specifically mentioned by the appellant. This also includes all legal errors, errors in fact-finding, failure to follow Manual M21-1, Manual M21-1MR, failure to discharge the duty to assist, and any other due process errors. This is a blanket statement that I recommend you add to whatever else you're going to add, put in that Form 19, because it's going to, without going into the legalities of it, it's going to preserve your rights to appeal a lot of different issues that you may not have thought about yourself.
Tom, that was great. Good show. And I hope this information has been helpful. If you get to the point that you want to appeal a claim with the Department of Veterans Affairs, the information provided is invaluable. Hopefully you won't get there and they'll approve it the first time around. And with that, we will bid you a fond adieu.
Hey guys, great information. Dave Culmer, our in-house VSO, and Tom Clewis of the law firm Thomas Monroe Clewis. Thank you guys.